Members, I think I'll just present from here for the, our final, this is our final bill, right? The 2542. This is, you've heard all of these bills that are in my delete all, and they're put before you as a policy bill. So I will move House File 2542, and then I will move the DE 3 amendment. And the House Research summary that you have before you is to the DE amendment. And you will note that it is basically each section is one of the bills that we have heard. All these bills have moved through committee: 1571, 2017, 1574, 2273, 2542, 1511, 495. And thank you to Ms. Dyson and Ms. Mullen for a very comprehensive bill brief. So they are all bills that you've heard, but we have significant numbers of amendments, and so I think maybe we'll. Okay. First of all, I'm going to, so I've moved House File 2542, and I've moved the DE3 amendment to get it before us. All in favor of that delete all, say aye.
Aye.
Those opposed, that bill is before us. Members, would you like House Research to walk through the bill before we go to amendments? I see a few people who would like that. So, Ms. Mullen or Ms. Dyson?
Chair and members, I'll start and I'll pass it over to Ms. Dyson when we get to the bond sections. Sections 1, 6, and 9 and the repealer in this bill are from House File 1571, which was Representative Howard's bill. It deals with manufactured home park closings. It amends current procedures that exist when a park owner is going to sell the park, and this section updates the notice provisions and the requirements for park residents who want to purchase the park. Sections 2 to 5 and also 10 and 11 are from House File 2017, and they make changes to the Manufactured Home Park Relocation Trust Fund program, including increasing the balance of the fund.
Madam Chair,
Ms. Dyson?
the next provision, Section 12, is from House File 1574, and it provides for maintaining affordability of publicly financed housing for at least 30 years. It's permitting the agency to impose rent, income, or rent and income restrictions on multifamily rental housing developments as a condition of receiving financial assistance, and that will be effective in 2020.
And that was the Hornstein bill, I believe.
Correct. And then Section 13 is from House File 2273, and it's striking language that was added to the Omnibus bonding bill last session that would have opened up low-income housing tax credits so that there were no restrictions based on a per-unit cost limitation or reasonableness or other restrictions for the allocation of those. And so this is striking that language that was added in the bonding bill last year. And then sections 14 to 40 are the that's the Minnesota Bond Allocation Act for residential rental housing, and it's defining terms and prioritizing among the types of housing projects, and it represents the consensus items of the housing advocates. And I
Chair and members, this is Mary Mullen from House Research.
Mullen?
Thank you. Sections 41 to 43 and then section 47 are from House File 1511, and they amend when the court can grant discretionary eviction expungements and when the court must grant mandatory eviction expungements. These cases can be brought on motion by the defendant, the tenant, but also can be ordered directly by the court. And it also requires evictions to be non-public prior to the court's decision. Sections 43 to 46 are from House File 495, and they add new lease requirements to Chapter 504B. That includes identifying the unit and the move-in and move-out date on leases that tenants sign, and also requiring tenants and landlords to have the same notice periods for increasing rent and move-out. And that's everything.
Any clarification before we go to amendments? All of these, again, were heard. You recall that that bond allocation one, that was the one that came over from Senator Weber. And then we had that's an agreement that I think goes back to discussions in 2017 they started with all of the housing advocates. Representative Howard, you have a couple of amendments. We'll start with, I think yours is, the A2 is yours?
Yes, Madam Chair, I'd move the A2.
Representative Howard moves the A2. Please speak to that amendment.
This amendment deals with House File 1571 and is a product of continuing to work with the stakeholders. After this bill was heard in the House Committee, we added some language in working with the manufactured home owners dealing with putting up the residents or those acting on their behalf putting up earnest money or a bond of some kind in case the deal doesn't go through. And so this language in the amendment addresses that issue and continues to clean up that language.
And you've been working with a variety of stakeholders on the A2. I'm going to just always check if there are members of the audience who want to speak to any of these. Do we have any testimony to the A2? Any questions of committee members? Okay, the A2 is before us. All in favor say aye.
Aye.
Those opposed? That amendment is adopted. And I believe the A6 is yours as well.
Yes, Madam Chair, I'll move the A6.
Representative Howard moves A6.
Again, this amendment is the product of working with the stakeholders. Members, you might remember we had a discussion in the House Committee about language, about who are the residents that would be able to sort of sign on the dotted line to reach the number of 51%, so to speak. And we had a discussion about is the appropriate terminology resident or tenant. And so we've worked to clear that up when we were in front of Commerce to make it clear that we're talking about residents. And this amendment in working comes from the manufactured homeowners to further clarify that we're talking about a resident who is a signatory to the home's lot lease agreement, just to add further clarification about who is able to be party to that moving forward.
Anyone in the audience who wishes to speak to this amendment? Any questions from the committee? If not, the A6 is before you. All in favor say aye.
Aye.
Those opposed? That amendment is adopted. And the A3 is a department amendment, and I would ask what, a member from the department, the A3 is a department amendment, I believe. If you'd come forward to speak to that. You may recall, members, when I presented the 2542, that was the bill that came over from Senator Weber, that the department at the time came forward and said there were, I don't know if these are technical in nature or, welcome to the committee.
Thanks, Chair Hausman, members of the committee. I'm Ryan Baumtrog, Assistant Commissioner for Policy at Minnesota Housing. Just want to say thank you to the chair and author of the bill. The changes in front of you in the A3 amendment are changes that the agency has provided to help with the administration of the program. This relates to how the state allocates bonds. In this case, it's actually Minnesota Management and Budget that allocates these bonds, and these will help clarify that process. We are continuing to work with Minnesota Management and Budget. They may have additional changes, but to meet the deadline and just to keep the process going, we wanted to get these in front of the committee as soon as we could. So just wanted to say thank you for offering these amendments.
And you would describe that as technical changes to the bill, would you?
Yes, I would say they're largely technical on how the bonds are allocated.
Is there anyone in the audience who wishes to speak to this amendment or members' questions to this? If not, the A3 is before us. All in favor say aye. Aye. Those opposed, that amendment is adopted.
Thank you.
And then we have the A4. Representative Heiss, is that one yours?
It is. Thank you, Madam Chair.
Representative Heiss.
When we heard 1511, there was quite a bit of concern considering the expungements, and quite frankly, as a landlord, I'm made responsible by some forms of government of what my tenants do. And so it's very hard to look at renting to someone where I really don't know their history. And some folks are very willing to talk about it, which is great. That is just fantastic. At least I know where I'm starting from. But to not know anything that's happened within, several years is really quite concerning. And I think it really does hold a lot of folks back from renting to certain folks. So what this amendment is just putting in some exceptions about, some behaviors that would really be quite concerning if we didn't know about it. And I would ask that folks support this because, several of them deal with, furnished alcohol, tobacco, and such to minors, and also smoking. We've had no smoking homes for forever, and I can tell you that at one point when a group moved out, we found out that a sofa that they left behind had actually had little beverage holders in the arms, but they also used them for ashtrays. That's really concerning when I think a house could have burnt down because they were using their sofa as an ashtray in a no-smoking home. So I really think it's really hard. I get why there's so many laws with landlords, but gosh darn it, it's really hard to rent out when you can't know anything and you just got to trust the person for what they say. And we've been hit with it several times. And also, evictions are not cheap. I don't want to evict. It costs money. And with that, I think, some of the others can speak if they want to. I wish Nels were here, Representative Pearson, because he was really good at vocalizing what some of those concerns are as well. But in order to have a really good lease where I feel like I'm really leasing to somebody where I know who they are and they're really coming forward and saying, letting me know what's going on as well, just makes a better situation for leasing. I don't want to evict. It's expensive. It takes a lot of time as well. So I just hope that we can get your support. Thank you.
Representative Munson.
Thank you, Madam Chair, and Representative Tice. Thank you for bringing this forward. This is really an important issue. When I heard this bill, I've mentioned before I've been a landlord for 25 years, and mentioned to Representative Tice that last night I had a long conversation with my wife. We're having to go through our first eviction process in 12 years, and this is a tenant that moved in 3 months ago and didn't pay rent and hasn't paid rent since they moved in. And has subsequently, there's people living in the property that we don't even know. She went and basically sublet the property illegally and collected rent for 2 months from the people that are living there. We have to, it's really frustrating, but the person that we're evicting, I think that future landlords should have a right to know that she's being evicted. She's not going to use me as a reference. So the only thing that landlords can have to see that this is a bad tenant is to have this on record, and to not have her be able to have it expunged, and to make sure that that's on record when it's filed. It's really expensive to evict someone, and we have made reasonable accommodations to try to allow them to get caught up on rent, as we've done in the past, which has always worked out for us, where we haven't had to evict somebody. But this omnibus bill in general removes a lot of landlords' ability to make some reasonable accommodations and exceptions to help tenants stay in the property, to make things more affordable. But this provision, where it can be expunged so easily, it makes it difficult for landlords to screen tenants, to screen the bad apples out, and to make sure that we can make accommodations for tenants. So I support this amendment, and I think it really lays out some exceptions that prevents expungement of evictions when it's very obvious that these tenants should have been evicted. So I thank, again, Representative Tice for bringing this forward, and would urge members to vote yes.
You may recall, members, when this bill was before us, we had some of this discussion. I wonder if there is anyone in the audience who was present then who testified at that point whether they would be willing to come forward. I see one person stepping forward. Welcome. Please identify yourself for the record. From Homeline, I believe.
Yes, Representative Chairman. Again, my name is Samuel. I won't repeat my introduction from earlier today. I would say that there are several problems with this amendment. First, it applies to both the discretionary and mandatory expungements. The discretionary expungements already requires the court to make a finding that the case is no longer a reasonable predictor. It would completely remove that discretion from the judge. It would just say you can't do it in any of these cases, regardless of what the circumstances are now. An even bigger problem is that it says if the basis for eviction was because of tenant. Evictions go on a tenant's record the moment that they're filed. They're a public document, so once the case is filed, they're there, which means that a landlord could go file an eviction, be wrong about that eviction, but under this amendment, if the basis for that eviction was one of these categories, the tenant couldn't get it expunged because it was the basis for the eviction. There's no requirement, in other words, of proof. The landlord doesn't have to win an eviction to establish this. So evictions that are just filed alleging things, true or untrue, would stay on a tenant's record. This also is, I think, fairly broad. Evictions often name multiple people. You know, this comes back to the discretionary issue. If there are multiple tenants, one of whom, maybe a roommate, significant other, something along those lines, uses, for example, an illegal substance, a drug, both tenants might be evicted. If those tenants aren't living together, the tenant who didn't do anything wrong can't go back and get their name expunged or removed under this amendment. I'll end there.
Questions of the testifier? Representative Fisher.
Thank you, Madam Chair. I'm noticing that it was saying the basis for the eviction right now, the way the language is in the bill, if somebody ended up where the judge found that they were evicted for, say, malfeasance or for violations, how long would that, under the current language, how long would that remain on their form or on their record?
Mr. Spade?
I'm sorry, if I could ask for clarification, do you mean under the laws that exist currently or under the bill as it is without the amendment?
Madam Chair, testifier, it would be under the language in the bill that's being proposed right now.
It would be for at least 3 years. After 3 years, under the mandatory section, it would the tenant would have to make a motion and it could be removed at that point.
Representative Fisher?
Thank you, Madam Chair. So basically, is if somebody is found to have actually violated this will still be on the record. It will still be available for people to be able to see when they're searching the court documents then, correct?
For 3 years, yes.
Okay, thank you. I just wanted that clarity.
Do I see any other questions? Representative Tice?
Thank you, Madam Chair. I just wanted to state again that a lot of the things that we're talking about here in the amendment are things that are they're quite serious. And as I said before, I'm made responsible for a lot of the activities that our tenants have simply because we're the landlord. And if I can't really justify, I guess I look at if I can only look 3 years and somebody has been acting very irresponsible, that really is not a good thing. To have them, if they know there's a 3-year penalty, 3-year look at, that we can only look 3 years, believe me, that'll be known. We've had some really bad actors in several years, and we don't do a lot of evictions, but when we do, it's a scenario very close to what Representative Munson said. They moved in May. We evicted them in April, never got any money. They never paid us. They got money. They were on services and never gave us a penny. And the house was so ransacked that it took us a lot of money and time to clean it and get it ready for the next people. That's a big investment, plus the investment it takes just to go through the eviction process. And I really think we should have the opportunity to look at some behaviors and say, you know what, we really do need to have a look at this so that we can make good judgments on who we want to rent to. Maybe then it's a way folks, tenants now know that they have to behave well, or they're not going to get maybe another chance for another 3 years. I can see that. But, some of this goes a lot further than that. and it's very expensive. So if we want to talk about keeping housing affordable, then we got to look at some options where we have to also work with landlords and say, you know, yes, we understand why you want to have the opportunity to look back at things like this. And also, Madam Chair, I would like to request a roll call.
A roll call's been requested. Representative, did you have any follow-up? Representative Johnson?
Chair Hausman, Representative Tice, thank you for bringing this amendment forward, because it has some very key issues in it. One, if you have a tenant that's harassing and stalking other tenants, I think a landlord needs to know that, because if they rent to somebody, they can be held liable if something happens. It also requires that if a person is engaged in prostitution, selling drugs out of their apartment, possessing illegal firearms, they can be evicted, and the landlord they're looking at in a new facility or new place to live can see that. To know that type of person, that maybe there's children around, you don't want that person dealing around those children. Possession of explosive devices, AEDs. It's an issue that we deal with in law enforcement, always are looking for and looking at. Trying to find those things to protect our citizens. I've actually been involved where we found a pipe bomb. We want you want people that are building those devices in your apartment complex? Absolutely not. And giving alcohol and drugs to kids? You do not want them by your children. This is a very important amendment, and landlords need to know this information, because they can be held liable if something happens. If they're not allowed to see these things, we might have less landlords and less opportunities for people to rent apartments that need them, and even have bigger housing crises.
Mr. Spade, it did occur to me that in some of these cases, when these are serious crimes, they are probably arrested, convicted, and perhaps in a correctional facility somewhere, and no eviction is going to be necessary because they won't be living there anymore.
That would often be the case, and in many of these cases, even if the eviction was filed and then expunged under this, it doesn't remove the criminal conviction, which landlords also search for and would be able to find.
Representative Hurt.
Thank you, Madam Chair. Just a quick question, and I can't remember if I said this in judiciary or in this particular committee, but I think that what our colleagues here have demonstrated is that we have a lot of great landlords. There are a lot of really good people who try to do right by their renters, but I'm a little bit challenged with this, because we also hear on the flip side that there are a lot of people who are wrongfully evicted, or people who are treated poorly. We had people who've testified around, asking landlords to do the bare minimum and then them getting evicted because they're asking too much out of landlords. And so I'm challenged with being able to creating these exceptions for for landlords, but I don't know if we have the flip side for tenants who are harassed because of their religion or their race or their gender, the tenants who are treated poorly by their landlords because their landlords won't even keep the units to just basic code sometimes. And so though I'm not opposed to protecting landlords, because I do have family members who own properties who rent as well. I have seen the way some of the properties are left after somebody has not been respectful, but I also have seen on numerous occasions, more often than not, people who have been unfairly evicted or treated poorly because of all of these same circumstances. And so I guess what I'm asking the testifiers that, do we have these same types of protections for renters and individuals under these very similar circumstances when they're harassed by their landlord or by other tenants in the building, or when they are, they've paid their rent, but their landlord doesn't do what they're supposed to be doing to keep the units in good shape. And so I don't know if there is an answer, and maybe there is. I would just like to know if there are the flip side to protect renters as well, versus just looking for something to protect the landlords.
Mr. Spade.
In many cases, I would say that there are protections for tenants for that, though you covered a very wide range of landlord activities. There are protections for many of those. Some of them are harder to enforce than others, but especially when we're talking about the difference between, say, expungements of an eviction record or repairs, getting repairs is very important. You know, at Homeland, we often talk tenants through how to do that. But expungements often go to the heart of whether the tenant can find housing and whether the people who live with them can find housing, whether they can live essentially in a home or their car, or a homeless shelter, or those types of things, which have a bunch of other costs, both to the tenant, their family, and society as a whole.
Representative Munson.
Thank you, Madam Chair. Trying to figure out how to make an argument here so that the other side can actually listen to understand how important this issue is for me and for landlords. It is, right now we have a housing shortage. That's why we're here. We're discussing legislation to help us make the right decisions and improve, get more landlords involved in building housing. What I've gone through in the last week dealing with this potential eviction is put such a distaste in my mouth for being a landlord that I don't even want to do it anymore. It's frustrating dealing with tenants that take advantage of a situation like this. And when you have a housing shortage, you have a lot of people that apply for the apartment when you have a unit that's up. And landlords have discretion of choosing who they want to have as tenants. We have kind of rules that we put in place on first in, if they meet the background check and whatever, that we'll choose. But you're taking away from us something that allows us to make a decision based in fact. I can look at all these tenants, regardless of race, religion, my gut feeling from meeting them, and I can make a decision based in fact. This person may not look the most appealing tenant to me based on whatever other stuff that might influence my decision, but if I know they don't have an eviction, then I can take a chance on that person. I feel so sorry for someone who falls into this class of people where they have a high rate of evictions, that they're discriminated against because people might think that they had an eviction that was expunged, or that something isn't that the landlord can't make a decision based on fact. And having this information out there that just says that an eviction is that they had an eviction allows me to make the right decision and take a chance on a tenant who's doing everything right and did not have an eviction. If you take this away from me, then you're gonna have other landlords that make decisions that aren't based on fact, and that's where we're not being fair to people. That's why this is such an important amendment that I think is going to help us make the right decision. Yes, there are bad actors out there, Representative Herr, and there are bad landlords that are evicting people that shouldn't. And you fix that by changing eviction law. You don't change the rental law based on something that is bad. Go and fix the actual the process by which you evict somebody in judiciary, but don't do it here penalizing landlords, which this bill, if we don't accept this amendment, we're going to increase costs. This is the first eviction that I've done for a property that's owned by a business. As many of you have realized, working at the legislature, you lose a significant amount of income to come do this, or many of you might. And under federal Fannie Mae guidelines for underwriting, I can't buy a house or even refinance my home because my income's dropped more than 20%. So I have to get a commercial loan for properties, and I have to put it in a commercial name. And I find out yesterday that when you evict somebody, if it's owned by a business, you can't, as the owner, you can't represent yourself in court. My wife went to law school. She can't even represent herself. We have to go hire a law firm. But the tenant laws, because of lobbyists like this, that got through that says I can only charge $5 for my attorney fee if we successfully evict somebody. That really penalizes landlords. That increases our costs. That's an example of the tenant-landlord pendulum that swung so far in favor of tenants. Now, I don't want to wait at all if I have to evict somebody. Now I'm out 3 months' rent, probably a security deposit, and and I can't even recapture attorney's fees, and I have to hire a law firm to come in and represent us. This is frustrating. I want to lower the cost of rent, but you guys keep on adding to our expenses as landlords, and it's frustrating. This amendment would allow me to make a proper decision based on a tenant application, based on fact, and not just choosing the tenant that's going to best suit me, but actually allowing me to take a chance on people. So I know if you've caucused this amendment, you've said we're going to vote against any Republican amendments. I'd urge you to consider this one. It still gives you a lot of what you want, but it's a compromise. and it's going to help lower the cost of rent.
Representative
Madam
Howard.
I'll be brief. I know we'll be back working on these issues, but I do want to speak against the amendment. And looking at the language of the bill and some of the egregious examples that have been sort of discussed, I think would be covered under this no longer reasonable predictor. Some of the scenarios, I think, would be a predictor. But the
Can you cite a page?
so I'm looking at line 34.2.0. If the court makes the following findings, the eviction case file is no longer a reasonable predictor of future tenant behavior. I think some of the egregious issues we're talking about would be a reasonable predictor. But the tenants that I want to just talk about are, and I think are probably the majority of folks who this legislation is important for, aren't folks that have participated in some malicious behavior, aren't folks that have created some scheme to, make their own money, and as Representative Munson's example, but it's folks that, might have lost a job and fallen on hard times and not being able to afford rent. Someone that maybe their mother or their father passed away and they had to attend to their funeral and fell behind on rent. Somebody who was fleeing a situation of domestic abuse. Some of those Minnesotans end up with an eviction on their record, and it's a black mark that they cannot come out from. And those are the Minnesotans that I think why this particular part of the bill is important, to look at expungement for Minnesotans that aren't, committing some sort of malicious act, but because of our current structure, and I do think that in terms of the pendulum, I think the power structure does lie more so with our landlords versus our tenants. And this is a reasonable way to provide a path for Minnesotans to sort of get out from this black mark of an eviction when they've fallen on hard times and are in a position to come back and have stable housing going forward. And this amendment, I think, is a little too prescriptive on some of those items and won't allow for that flexibility, and so I'd speak against it.
We're going to go with Representative Gunther, and then concluding comments from you, and then concluding comments from Representative Tice, if we could. Representative Gunther.
Thank you, Madam Chairman. I think we have to watch what we're doing here because the pendulum can't swing too much one way or the other. I at one time owned 47 apartments. Because of problems with tenants and the way they left my property, I own 0 today. I enjoyed a lot of those tenants, and I hated some of them. But only after they stepped on me did I dislike them. I did everything I could. If they had a problem, I never had a search company ever search a tenant's ability to be a good tenant. There are those organizations out there. That does nothing more or less than raise the rent. Because every tenant that doesn't watch his bottom line, or landlord doesn't watch his bottom line, isn't going to be a landlord very long. And 47 apartments are no longer there in Fairmont, Minnesota area because of some bad tenants. At the same time, I've known slum landlords that I wouldn't recommend anybody rent an apartment from. So we got to watch where that pendulum swings. This is the only thing going in favor of the landlord that I've seen in this committee. Everything has been skewed towards the tenant. Don't let the pendulum swing too much or you're going to cut your nose off to spite your face.
Mr. Spade, any concluding remarks?
Thank you. I'll keep it very brief. Certainly, I understand the issues with tenants who do terrible things, a pipe bomb in the building, for example. But this amendment, as it is, simply isn't specific enough to those things. It also includes much less serious issues, such as not paying rent for 2 or more consecutive months, which could just be to a financial problem, or repeatedly smoking in a smoke-free building. Those are not on the same level as a pipe bomb, and yet both are included. And second, it's just it's the bright line nature of this rule. It just says you can't get an expungement if one of these things exists. It doesn't allow for discretionary expungement, for example. It's not just dealing with the mandatory expungements. It's dealing with these discretionary ones where, again, there might be other factors. multiple tenants where one of them should have it expunged and maybe the other one shouldn't, et cetera. So I would just say that as written here, it doesn't quite get at some of those concerns the way I think that it might be intended to.
Representative Tice, final comment?
Thank you, Madam Chair. And I just wanted to let Representative Hurd know that in St. Cloud, when you apply for a rental license, you have to take a training. You know, it's just mandatory. So a lot of places, I think, do that as well, so that we know what we can do and what we can't do. And that's a good thing. But I think my hair just stood up when you mentioned a pipe bomb versus smoking repeatedly in an apartment. And I would say I almost think smoking repeatedly in an apartment is worse than finding a pipe bomb, because smoke will mean, in a smoke-free building, means I got to clean that bugger up as good as I can, because I'm advertising it as a smoke-free building. And smoke is one of the hardest things to get out. So that means I'm reflooring, repainting, I'm cleaning everything I can. And so to make it sound like that's a trivial thing is grossly not. It makes a big difference. And yet, part of it is, those are the rules of the game. When you rent the place, you're renting a smoke-free building. That is part of what you agree to. And so that kind of got me a little hot when you kind of made that. I would rather someone not smoke than anything else. And we've had folks that have done that. As I said, we had a group that cut little things in the couch and used those for ashtrays. Wow, you know, that just blew our mind when we found that. And we didn't know it until after they had moved out and left half of their stuff there, because it was horrible. You got some time, I'll tell you the whole case of that one. I mean, it's a lot of work to get an apartment back again. So with that, I just hope you can find a place where we can truly look at some of these things and realize that it is a deal breaker for some folks for renting out apartments. And also, if we want to keep costs down, it means we have to have good tenants as well as good landlords. Thank you.
Members, we're going to have a roll call vote on this. I would recommend a no vote on the amendment. The bill itself has a very little step toward tenants' rights. We haven't done much for tenants' rights for quite a number of years, and this moves a little bit in that direction, as Representative Howard mentioned, that pendulum needs to be balanced a bit. So I would recommend a no vote on the A4, and please take the roll.
Hausman?
No.
Howard?
No.
Tice?
Yes.
Bierman?
No.
Fisher?
No.
Gunther?
Yes.
Hassan? Burr?
No.
Ornstein?
No.
Johnson?
Yes.
Jurgens? Munson?
Yes.
Pearson? Poppy?
No.
Sock?
No.
Eight to 5, that amendment is defeated. Members, we have two more amendments, and the next committee is waiting outside, and so unfortunately, I think we're going to have to come back. Can you give us the room and time? 1:20 in the Capitol. We could not get a room here at 6:30, so we'll have the last two amendments and then final passage of the bill. We are in recess.